Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. We are in April. I cannot believe it. This year is going by much too quickly. Today, my daughter reminded me, Mom, it's only 3 years until I go to college. So, anyway, that's not how you want to start your day. But I'm so happy to be here with all of you. So here's the thing. The new president has been in office since January 20th. Today is April 2nd. And we've got some interesting things to report. There is never a shortage of interesting things to report with this administration. So here we are talking about the EEOC's enforcement guidance that came out late last month on unlawful workplace DEI programs. Okay, so first of all, let's be clear. The president has issued several executive orders relating to DEI programs, okay? The EEOC finally issued back in March guidance regarding the DEI programs and the use of the term unlawful discrimination that is in the executive order. So what happened was the president's perspective is that these DEI programs result in unlawful discrimination. So he directed the EEOC, who has, as you're probably aware, a new leader, to issue some guidance. They issued the guidance on March 19th. So first of all, I want to talk to you a little bit about the background so you understand what's going on. The new chair of the Equal Employment Opportunity Commission, which is a federal entity, is Andrea Lucas. Okay, she is a huge opponent of DEI. She never has said anything positive about DEI, and she, as the acting chair of the EEOC, she actually ousted 2 Democratic commissioners. That's all very interesting in terms of whether they even have a quorum. So that was one set of sort of executive orders. And then President Trump also revoked an executive order from a prior administration that mandated affirmative action requirements for federal contractors through the Office of Federal Contract Compliance Programs, which is now defunct. So we now don't really have an OFCCP. Again, we've got a lot of lawsuits and a lot of court decisions that will be coming out to help us figure out what's going on. The issue we're going to talk about today is the January 21st executive order that relates to DEI and defines prohibited conduct relating to DEI as illegal discrimination and preferences and workplace balancing based on a protected category. Now, here's what's so interesting, you guys. Neither of those things, illegal discrimination and preference or workplace balancing based on a protected category, have ever been legal. They have always been prohibited by Title VII, and they are prohibited by California's Fair Employment and Housing Act. They have never been lawful, okay? Now, there are very limited situations in which an employer, because of historic past discrimination, has been ordered to remedy that past discrimination through a consent decree with the court. And a long time ago, some of those consent decrees dictated quotas, dictated workforce balancing, that sort of thing. Those are long gone, okay, except in very narrow circumstances. For 99.99999% of you on this call, your DEI programs have always been lawful because you don't have illegal discrimination and preferences, and you do not do workplace balancing. The thing is, though, there are some components of DEI programs that you need to be careful about. And there are some common components that I have seen that I am worried about. I was worried about them before these executive orders, by the way. They have always been a problem, these components. Now, by the way, before we go into that, I want you to remember something. There are plenty of court challenges still going on. So you'll remember the district court judge in Maryland back in February blocked part of the DEI order. Then in mid-March, an appellate court overturned that, giving the administration the go-ahead to proceed with the enforcement of the order until the lawsuit winds its way through the court. It's obviously going to end up at the U.S. Supreme Court if they take the case. And who knows? Remember, the U.S. Supreme Court never has to take a case. They can deny cert. Okay, so they can say we're not going to allow this case to come up on appeal, in which case the Court of Appeals decision will remain in play. So these documents that the EEOC released on March 19th do provide some clarity to employers. That's the good news. So they make clear, for example, that there is no such thing as reverse discrimination. So regardless of who is harmed, whether they're a, quote, majority group or a, quote, minority group, there is protection under Title VII. Same thing with California state law, same thing with all other state laws, okay? There is no reverse discrimination. Title VII's protections do not only apply to individuals who are part of, quote, a minority group. That's what the technical assistance and the guidance says that the EEOC issued. They apply to, quote, majority groups also. So therefore, there's no basis for having a reverse discrimination claim. Now, that's interesting because the U.S. Supreme Court is going to be looking at a decision. They just held argument about a month ago, looking at a decision where reverse discrimination is at issue, and we're going to see what they have to say. But from the EEOC's perspective, it doesn't matter who you are, you're protected under Title VII based on your race, your ethnicity, your national origin, your sex, and your religion, okay? The next thing the guidance talks about is whether there is an exception for these DEI programs that would be based on your business needs. Okay, so in other words, do you get to say, well, we can have an unlawful DEI program because we have a legitimate business reason to do it? Our workforce doesn't look like our community, and therefore that is going to be a legitimate justification for having a DEI program. As you may recall, Title VII does allow for what we call a bona fide occupational qualification, right? So if somebody wants to be a Victoria's Secret model, they're going to have to meet some very specific requirements based on age, based on sex, based on race potentially, based on ethnicity, whatever the creative director at Victoria's Secret wants to see done in a particular show or a particular catalog, they're going to pick people who fit that mold. And they may decide not to give somebody that job because of what they look like. In fact, that is the only reason likely that they would not give someone that job, because they don't fit the physical requirements for the position. They don't look the way they're supposed to look as a Victoria's Secret model. Okay, that's a BFOQ. Now, what is interesting is that when you look at BFOQs, there is never a BFOQ for race or color. Okay, you never get to have a BFOQ for race or color. You can for sex, right? But you can't for race or color. So that becomes interesting. And the EEOC said, look, we agree with that. And we don't think that there should be any exception, any sort of business justification for a DEI program that is unlawful. Now, remember, you have to keep in mind, what is an unlawful DEI program? Well, according to the EEOC, remember, it's one that results in illegal discrimination in preferences or one that is focused on workforce balancing, okay? So a quota, in other words, that's what workforce balancing is all about. So the guidance made that very clear. Now, oh, and I should tell you this. The other thing the guidance did is make clear that it applies, that Title VII and the order are going to apply to anybody in the workplace. So paid interns, unpaid interns, employees, anybody, an applicant, for example, somebody who participates in a DEI training program will also be protected, okay? So when you look at the EEOC guidance, what you have to remember is that if an employment action, hiring, firing, transfer, leave of absence, reasonable accommodation, bonus, compensation, raise, whatever it is, if it's motivated in whole or in part by an employee's protected characteristic, it is illegal, okay? So as I said, you realize if you're going to segregate employees based on a protected characteristic. For example, you have an employee resource group, an ERG, and you say, hey, this is our woman employee resource group. Well, that's a problem. And by the way, it's also dumb as a box of rocks, because if you're going to have an employee resource group where you want to encourage inclusion, why would you exclude 50% of the population and say only women can be in this ERG? Or why would you exclude certain races or colors or national origins? It makes no sense. You can have an employee resource group, but it needs to be inclusive, not exclusive. You have to make sure that you don't have quotas. You're not trying to balance the workforce. You have to make sure that your DEI training is not a problem, okay? So you have to be careful about the examples you're using and how you're conveying your message in that training. Obviously, of course, Title VII protects against individuals who are impacted by a rule that or a policy that seems neutral, right? So if you were to say, all of my security guards have to be 5'10", neutral rule. I'm not saying anything based on sex or race or national origin, but we know it's going to have a disparate impact, right? We know that different races and sexes are going to be negatively affected by that requirement, right? Obviously, also Title VII protects against retaliation. So nobody can be retaliated against, the guidance says, for engaging in protected activity, making a complaint, participating in an investigation of somebody else's complaint, making a reasonable accommodation request, asking for leave of absence, filing a workers' comp claim, etc. So what you have to be careful of is you cannot have hiring quotas or supplier quotas or policies that limit speech that is content-based, right? So you can't say, oh, if you want to talk about supporting the administration, that's fine. But if you want to talk about anything negative, you can't do that. Okay. And all of these sorts of cases are winding their way up through the courts. We got to make sure you don't have an internship program or a fellowship program or a mentoring program that is based on a protected characteristic. Base it on income. Base it on them going to a Title I school, right? Where it's clearly in a neighborhood that needs some additional resources. That would be something legitimate you can do because income is not a protected category. What should you do? If you've got a DEI program, you got to look at it with your lawyer. And it needs to be a lawyer who knows what they are doing when it comes to DEI and these executive orders. You do not want to be taking a risk. You also probably don't even want to call your policy a DEI policy or a DEI program. You want to come up with something different. Why even encourage anyone to come look at what you're doing by what you call your policy? You've also got to train your HR folks, your frontline supervisors, your management team, your leadership team. You've got to make sure that every decision you make in the workplace is well documented and it's clear why you made the decision you made. So you guys, look, the executive order, it doesn't change much. To be perfectly honest, the things that the order is focused on were already prohibited. But we're now in a game of perspectives. We're now in a game of what does it look like? So think that through. You're going to want to be strategic about how you roll out your plan, what you call it, what you do with it, and how it is implemented. Okay, stay tuned for more information on this one. I am sure we have not heard the end of this. Thank you all so much for joining me today. Go out and have a great day and enjoy this lovely spring weather. I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.